This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.
Good evening. My name is Joe Sam Robinson. It's my pleasure to have with us once again Mr. Buck Melton. Welcome, Buck. We've had you a number of times. We did good, enlightening discussions.
One tries.
And tonight, maybe we could talk about some of the recent Supreme Court decisions involving marriage, if we might do that.
Yes.
And recently, I think there was this was a 5-4 decision about, I guess, unrestricted marriage between anyone, pretty much. And you want to comment about that?
Well, I wouldn't say that's what the court said.
Oh, good. Why don't you tell me? So it's not
the polygamists may disagree with that.
So yes. Polygamy still doesn't. There are limits. It's still against the law to have more than one wife, I would say.
Yeah,
or one husband.
Well, we can get to that. The court didn't make everything equal. It just moved the bars to where the line between equal and unequal
Well, what exactly was the decision? What happened exactly? And
well, it came as a bit of a surprise that what I would have expected and what the U.S. government argued in this case was equal protection. If you look at the 14th Amendment, we've talked about this a lot lately when I've been on here. One of the key phrases of the 14th Amendment says that no state shall deny to any person within its jurisdiction the equal protection of the laws. And so the argument being made by the gay community was that state laws that denied the right of marriage or the privilege of marriage to same-sex couples were treating same-sex couples differently, unequally, as compared to heterosexual couples.
Yes.
And that is what the government argued. That seemed to me to be the most logical argument that the gay community had.
Yes, yes.
And the Supreme Court, in the end, in this 5-4 decision, did not go in that direction. Instead, it based its decision on what is called substantive due process. And it's all the more remarkable that the court based its decision on substantive due process because the government expressly declined to argue that issue.
And what is that? That's a good turn of phrase. Maybe you can explain that to our viewers and me also, what exactly that is.
Yes, there are 2 due process clauses in the Constitution.
Yes.
One in the 5th Amendment that applies to the federal government.
Right.
And one in the 14th that applies to the state governments.
Yes.
And the history of the due process clause goes all the way back to Magna Carta, and it essentially says that the government itself has to play by the rules. The government itself has to obey the law. Now, traditionally, the due process clause has been read as procedural.
Yes.
And to paraphrase it, if you read it procedurally, it says that the government cannot take away your life, your liberty, or your property without following proper legal procedures.
Yes.
For instance, the government can take away your life. It can take you to Jackson and strap you in and give you a lethal injection, but not until it's given you a fair trial and jury.
Yes.
Yeah. It can take away your liberty. It can throw you in jail.
Right.
It can run an interstate highway through your house, as long as it follows the law.
Yes.
Well, starting around the 1850s, you begin to see the Supreme Court on occasion give a different meaning to substantive due process, to the due process clause. It reads it in a substantive fashion. And if you read the due process clause to give it the language as if it's substantive, it would read, nor can the government take away your rights to life, liberty, or property, period. Mm-hmm. Full stop. No matter how many procedures it follows, there are rights that it can't take away.
So sort of natural God-given rights that are outside the purview of the state?
That's sort of a way of viewing it, except it's not natural, it's actually positive. It's written down there in that magical word liberty. So we come down to, if we're going to apply that substantive due process thinking, we're going to ask, what does that word liberty mean? The liberty to have a contract with your employer free of interference by the state, the liberty to own slaves, the liberty to quote unquote control your own body and have an abortion, the liberty to marry a person of the same sex. From the very beginning, the Supreme Court has always tried to find a constitutional clause that it can put anything it wants to in.
And it's found one, huh?
Yeah, and well, originally it was the contract clause, but for the last 100 years it's been the due process clause. And therefore, whenever the court invents a right, and it's perfectly clear that's what the court does, it always comes under tremendous criticism from one side or the other for having simply invented a right, legislated from the bench. And it can put a conservative right in, as in the Lochner decision, or it can put a liberal right in, as it is done in the same-sex marriage case.
So, I mean, going through the particulars of this, no matter which road the court elected to take, the results are the same. I'll make one comment about liberty. I mean, I'm thinking about libertas and getting libertine. But so there's a certain sort of, I guess, sexual innuendo about the word liberty. I would phrase it that. I mean, so people might choose sort of a slightly, I guess, less edgy word, but okay.
License as in licentious.
Right. So there's a lot of, it's a long, complicated story there. But what the government has done is it's really, and the Supreme Court has done this, it's changed the nature of marriage. Maybe we could talk a little bit about what marriage is and isn't, and why it's an important concept, if we can say it that way. So the courts have broadened access to this, but isn't there a difference? And is this some confusion about this? Is that the sacrament of the church is marriage, and and the churches control that, and that's their thing, and it's sort of a God-given responsibility and privilege. The church has the power over this, and then there's a civil union that seems to have some, it looks like society has given civil unions or something like that lots of privileges and prerogatives with the idea these civil unions would be in the state's interest. I mean, now is that when the court talks about marriage, it doesn't intrude into the sacraments of the church, does it? Is it mostly talking about, I mean, I don't know, but I'm throwing this out.
It remains to be seen.
So I mean, well, we can get into that. The civil unions, we can just go there a little bit. I think in our legal system, there's a tremendous number of financial advantages to be married. Is that correct? And the reason those advantages have been put in there is the state has traditionally encouraged these relationships for lots of reasons. One is propagation and secure families and good family systems and stability and just all the things that make the world work.
And don't forget to follow the money to have a fairly well-defined descent and distribution of the property rights of the parents.
Right, and the other thing that in this traditional viewpoint of what the state's role in this benefit would be, the idea that in traditional marriage arrangements, one of the partners would be focused on child care or would not be in the marketplace, and that person would be protected and have rights. So there's a whole litany of rights and privileges that go to the tax system. I mean, the way the coding, the tax arrangements go. Let's say married housing, just general, I don't know, airplane tickets, all kinds of legal things that are in our code to protect the notion of, if not marriage, at least civil unions. And so is the court speaking about saying we're going to give these benefits that traditionally the quid pro quo was the interests of the state would be protected? We're going to give these benefits to this group of people. And or is it going to help the state, I guess? Should they deserve that, or should anyone deserve it?
Well, Justice Kennedy's opinion talked about this a little bit. He would have talked about it a lot more, and I think he would have been justified in talking about it a lot more if he had gone the equal protection route. If you've got couple A over here and couple B over here, we'll say Adam and Eve here, and for the Buffy lovers out there, Willow and Tara over here, and Adam and Eve get all of these tax advantages and descent distribution advantages and right to sign off on health care for the other partner. And Willow and Tara, who are just as much in love in here, don't have the opportunity to get those rights. Yeah, you got an equal protection issue. But he mentioned those briefly, but he really just composed a legal poem to love and said, who are we to deny the love that Willow and Tara have? And so it wasn't an immensely practical opinion.
I found it, you know, sort of redeeming a certain sensitivity on the part of these elderly justices that the blue bird of love has flown in the
these
chamber
crazy
there.
kids, let them do what they want.
Let love happen, yes.
So, but you bring up an important point. I mean, where is marriage based? And I think it is ultimately based, and certainly the four conservatives hit this really hard, that it's based in biology. But there are major social and sociocultural and economic concerns that are grafted onto that.
Yes.
And since you have at least a potential for the interests of the one party to come into conflict with the interests of the other, for instance, who owns what, child support, you name it, a well-ordered society has to have an input into that arrangement. So is it something that is purely natural, or is something that is artificial based on society? Is a mixture of both?
Yes.
So it's a very complicated thing. And once again, I think Roberts pointed out that this isn't our call here, that this is a call to be made by society at large rather than 5 out of 9 people who simply create a new right by going
five
over,
lawyers.
Yes, who go over the heads of everyone else. I wish I had brought to read. There is you can look in Google this the Supreme Court decision on same-sex marriage in haiku, that someone has summarized all 4 of the opinions in this case in 4 haiku, and they are actually dead on for each one of those summaries. And Roberts is, we sympathize you, really we do, but this is not our decision. Whereas Alito's was, the real purpose of marriage, he said, whispering, is about babies. Thomas's is, I do not believe that John Locke means what you think he means. And Kennedy's majority opinion is love is love is love is love is love. It is so ordered.
Yes.
So,
well, I mean, just to go into this, I mean, you know, what I guess I'm attempting to talk about is marriage and civil unions.
Yes.
So the idea is this decision is not going to force churches of any type into sort of, or is it, to say, well, you have to, you now have a new protected class here. So this is protected class, and it may clash a little bit with religious liberty, but has the court created another protected class, and ergo, if you're not a protected class, are you an unprotected class?
Yes. Once again, not going the equal protection route, the court may not have said that same-sex couples are a protected class. And answering your earlier question, this decision itself, I don't think requires dissenting churches or religions to perform same-sex marriage. Now, does it open the door for further developments? Yes, I think it does. The majority, per Justice Kennedy, wrote one rather vague paragraph about how religions that have an issue with this will still have the right to preach different viewpoints. It doesn't say or to teach different viewpoints. It doesn't say they have the right to practice different viewpoints. And there's already been a lot of legal scholarship on this point, not just in the last few days, but in the last few years, that if a pastor has a license from the state or authorization from the state to conduct and witness marriages, he thereby becomes, for that purpose, an agent of the state. And if you're going to bring equal protection into this, can an agent of the state pick and choose whose marriages he is going to allow if the state has said all of these marriages are permissible? So I am expecting in the very near future to see someone file suit against probably the Catholic Church, because it's the biggest and most doctrinally clear institution that says marriage cannot be theologically between two persons of the same sex. I expect to see someone try to force that issue. What the outcome will be, I do not know. I do know that this case does not clearly say that the Catholic Church cannot opt out.
Well, now, in looking at this, I mean, I'm sort of trying to get into a little bit of protected classes and what occurs. You know, you mentioned earlier the idea of a due process would have been the easiest thing to do, but maybe the courts deliberately did not go the due process route with the idea.
They did go due process.
They did go due process.
They did not go equal protection.
Okay, excuse me why there. All
It's
right, so equal protection. Yeah, it's my brain, but so they went that direction. Now, is that what I'm considering? Is we have these the courts are basically sort of. Yeah, I have my analogy about the balloons and the little spear there, and they're inflating one balloon. They're inflating one balloon, the other balloon goes down. But presumably, does this give, let's say, a gay couple the rights to litigation if in some ways things are abridged? They, I don't know. We had this discussion about somebody wants a wedding cake. They have to break a wedding cake. Or they have to, I don't know, have a reception, and a gay reception after the marriage, and I don't know, whatever, the local bistro.
Yes.
I mean, and there's a series of rights that if that doesn't take place, there are going to be big deals. And indeed, is it also possible that the step the court took in this direction could mean that, I guess, gay people, wherever they are, and transgender people, if there was any sense that their rights were being impinged upon, that the heterosexual majority was doing anything that was, in some ways, abridge their liberty and selfhood, they could cause financial penalty. They could do things. I mean, I don't know. I mean, you could just go through all kinds of hypothetical cases, but I'll leave it at that. Do you have any thoughts?
We're just going to have to wait and see. Once again, if the court had gone with equal protection, I think the gay and lesbian community would have had a lot stronger basis. That is not to say that this case does not give them a basis. It just leaves a lot more, it probably raises more questions than it answers as to how far this goes. Kennedy did say that liberty and equality go hand in hand here. I'm not sure how that can be the case, because if we have absolute equality of condition in this country, then we can have no liberty. The nail that sticks up will be hammered down in the name of equality. So one, if you will, to use your analogy, you've got two balloons. One is equality and the other is liberty. As one expands, the other's got to contract. So if we go on an equal protection heading, and I have the equality to do this, then do you have the liberty to tell me you're not going to bake a cake? I don't know. That's problematical.
Now, one of the other, arguments. I mean, there are all kinds of events that are taking place in the world. We have this very, I don't know, exponential change. This is happening. That's happening. The human condition is still the same, but it's undergoing all kinds of, I guess, seeming differences. One of the things that's happened is the number of children born out of wedlock in the country has really rocketed up. It's about 40% of the country. So in other words, I was sort of making the argument earlier that the state has an interest in encourage, I guess, a stable family environment for lots of reasons. If you want to go through and look at the statistics, okay, you grew up in a stable two-parent household, whatever. This is what's going to happen to your, I don't know, educational thing, your brushes with the law, your just general, how useful a citizen you're going to be. I think it's fair to assert that the people growing up in that environment are going to be, with everything else, more socialized, more societally. It's a good thing for society to have that happen. And there's this traditional family arrangement is undergoing such an extraordinary change, an assault, I would even say.
Yes.
in some ways, the advantages the state bestows upon a man and a woman marrying, is that in some ways altered by this? We're protecting another class.
Yes.
We're saying you're a co-equal.
Yes.
Does that diminish the sort of sanctity? In other words, can you just bestow something on, give love to people or whatever, and without, in some ways, injuring this concept of a heterosexual marriage? Is that a question?
Well, yeah, that's a lot to unpack there. Well, if you can, let's just reverse that for a minute. If you can, who should be the deciding group? Should it be the electorate? Should it be the courts? And this is another huge criticism that Scalia and Roberts put forth, that these are policy decisions that the court shouldn't be making. The electorate as a whole should be doing this instead of the court taking it out of their hands and telling them, no, this is a constitutional right that you can't touch.
Right.
But even in doing that, it's simply moving the goalposts as well as opening the door to a lot of new questions. And maybe we do need these questions asked. You have, just in the past 40 or 50 years, you have in vitro fertilization, you have surrogate motherhood, you have, is it just recently that you have 3 parents by inserting the genetic material?
Right. All these things are biological things here.
So we're going to have to make some sort of accommodation or change to this. The question is, how do we make it? How quickly do we make it? Who in a society should make it? It's a real can of worms.
You know, it really, it seems to me a broader problem is the sort of the moral underpinnings of the society, the important, it seems to me rather glorious to, you know, the people leave the church and join holy wedlock. It's a rather beautiful thing to see, isn't it?
Yes.
I don't think anyone wants that diminished. But does letting Bob and Steve get together, does that diminish it? I mean, I guess that's a question to ask. Is that, and many people, that the situation has changed, the opinions have changed. 20 years ago, people would say, no, Bob and Steve, you know, that's not natural. But now, over the past 20 years, the country's apparently changed its mind on the subject.
Well, diminish, I don't know if diminish is the right word. I think that, you know, the one thing that Bob and Steve obviously cannot do is have a child themselves naturally.
They get surrogate mothers. But
yes, surrogates.
And they get a child.
And eventually, at some point, you're going to be able to combine both of, you know, their genetic material and do it. But you know, there are, once again, marriage has not always necessarily been about procreation. There are childless couples that there is not a requirement, except in Catholicism, there are no requirements that you will be fertile or try to bring forth children. But still, child raising has been a big part of it. So I would say not diminish, but speed up or emphasize the change in focus might be a longer and more complex way of putting it. My concern is this, and here's where I think that Kennedy's being hypocritical, that if you look at the...
And he was the swing vote in this.
He was it, yes.
And he's a Catholic.
I would say he claims to be Catholic.
Okay.
I don't know how closely he applies the Catholic faith and morals. But let's look at polygamy as an example. That historically...
In the Bible, it's in the Bible there.
Historically, culturally, there's a lot more argument for polygamy than for same-sex marriage. There have been scholars making serious scholarly arguments that, yes, it is quite possible to mandate that same-sex couples have the right to marry, while at the same time, couples who would be polygamous are denied that right. And I think that's hypocritical. The reason being that if the court, well, I'm getting ahead of myself here, that the one thing that you have always seen in marriages, always in every culture throughout history, and if I'm wrong about this in TV land, please email me and let me know, marriages have always, without exception, involved at least one male and at least one female.
That's,
So if
sounds right.
So that is the common denominator. If the court has now done away with that common denominator, then a fortiori, then we should be able to do away with any other element of the definition of marriage. But Kennedy went out of his way to keep on using this word couples, 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 as if he was trying to elevate to the American civil of religion that marriage must consist of couples. And maybe it should, but I don't know how you can say it must. And the hypocritical factor seems to me even greater, that my guess would be, and I do not mean to stereotype here, my guess would be most of the gay and lesbian community tends to be to the left, if only because the left-leaning party, the Democratic Party, has been more tolerant of gay and lesbian culture.
Yes.
Yes. Whereas I would say most would-be polygamists in this country,
Would be.
and I would say they'd be somehow related to
I like
offshoots.
that turn of phrase. That's
Yes,
good.
they're probably related to offshoots of the LDS Church.
Yes, yes,
I would imagine they would be right-wing.
yes.
And so to move the goalposts and to redefine marriage in a way that favors the left, same-sex couples, but does not favor the right, would-be polygamous couples, when there's a lot more socio-political historical evidence for the validity of their marriages,
Yes.
seems to me hypocritical in the extreme.
Well, I don't know if all the leftists don't want polygamy. I mean, I imagine there are a few leftists out there
I'm
that
stereotyping,
would
I
scratch,
know,
would scratch.
so.
But I think this is kind of what we discussed earlier.
Yes.
This would be my opinion. The people, the 5 people that voted for this on the Supreme Court, are in circles where the cultural arrangements they're in. I mean, this is, everyone would say this is a good idea. Every single person, and they would say it's wicked not to let these people love each other. I mean, to make the comment there, obviously they have this special kind of thing, and we want to do that, and their cultural values are so powerful that they are influenced by this. And whatever the logic of doing this is, it was like a situation thing, as we discussed earlier. I think, yeah, I'm going to let Bob and Steve get together, says the Supreme Court. What about polygamy? Well, that, even though it would be very rational to do that, it's totally rational to have polygamy if you have same-sex marriage. Totally rational, in my opinion. But the person would scratch their head. Do I want to do that? I don't think so. I don't know anyone that would want to do that. I mean, there's nobody in my particular. It just sounds a little strange to me. Why should I do that? There's maybe some crazy people out in these cults in the West do that.
Let them do it.
I mean, but the Supreme Court would, because there would be outcome driven, they would just make the contradiction in their opinion and polygamy would just not matter. I mean, it would there wouldn't be the compelling sense that after you've done this, the next step is that. And that there's not compelling pressure, but once again, I'm thinking legally that if the Supreme Court takes away the one thing that has been inviolate and violates it, it can't then turn around immediately and say there's something else that can't be violated. I agree with that. I mean, actually, I agree with that. And I mean, it may well be that we're going to get a decision. I mean, are some, I don't know, some people that want a polygamous arrangement. I mean, they're going to say, I'd like to get married, and Utah won't let me do that.
Yes.
And I'm going to take this to the Supreme Court.
Yes.
They probably wouldn't hear the case, would they?
Not yet, but give them time. My bigger concern is not with this opinion, but with what happens down the road. So it's no sweat off my back if Willow and Tara can get married, but as that balloon increases, I'm speaking as a civil libertarian from way back, does this provide the basis later on for coerced conformity that Bill here as a Catholic has not only got to respect their legal status as being married, that the ancient doctrines of his church have to be forced to knuckle under to the American civil religion.
We have all these complicated ethical dilemmas in our world here, and I mean, we just have to, everybody has to, like, I think about things and come up with their own notion of what's right and what's wrong. Well, on that note, okay, thank you for coming, Bucks. Very good interchange. Thank you.
This program is brought to you by the Georgia Neurosurgical Institute. For over 50 years, rendering neurosurgical care to patients of all social conditions, treating complicated problems involving the brain, spine, spinal cord, and peripheral nerves, endeavoring to encourage quality care, medical research, innovation, and education on a local, national, and international basis.